Hello friends, Namaskar. I am Anil Kumar Srivastav and present with you with the some important sections of the Constitution of India, and let us start. These articles are uh, subjected to the nearing examinations in which the only article is asked. So we have to uh, we have to uh, remember these articles. Let us begin with. I am now starting with the chapter 4, that is the DPSP, Direct Minister State Policy. The This chapter extends from 36 to 51, and let us start. The first section 36 talks about the state's definition. The definition of state is more or less the same which is in the Article 13, and it there are many instruments and many institutions which are uh, uh, come under the definition of the state. So it may be the collector, it may be the uh, corporation, it may be the government itself, it may be the Pramukh Sachiv, and these all are under the definition of the state, where they are drawing the money from the state exchequer, and the government has power to appoint him, government has power to uh, di- uh, to uh, dismiss him or her, and government has control on the functions of that institution, and government is giving aid to that institution. In all these cases, these institutions will come under Article 36, which are also defined in Article 12. So now we come to the Article 37. Article 37 states that the the principles underlying the are expanding from 36 to 51 are fundamental in the governance of the country or governance of the state, but these principles cannot be enforced through law. So this is the basic difference between the part 3 and part 4. Any kind of deviation or any kind of uh, interference from the fundamental rights that can be reached for the solution of this under Article 32 to the Supreme Court and under Article 226 of the in the High Courts. But it is here that the principles which are almost equal to the fundamental rights, but here the principles cannot be enforced through the court of law. But when the government is making the its policy, it shall apply these principles in making the laws. So we now come to the Article 38. Article 38 talks about that India is a democratic state. India is a welfare state, and that we should always give priority to the people who are uh, below the poverty line, and the policies should be made for them. And in 38.2 it has been added that the government, it is the duty of the government that that it should try in the political, economic and social fields to inform same social um, order, and this order should be similar to make the every region should have the same importance. We are talking about Article 39. Article 39 states are is well known for the equal pay for equal work, and besides this, There has been a provision that the ownership and control of the material resources of of the country should not be used for some persons, but it should be made that the capitalism and the uh, monopoly should not be done at any cost. And it it is also provided that the children should not be abused, and they should be given proper atmosphere so that they can develop. And Article 40, which is which represents that the Gandhian thought that it states that the state shall try to establish village panchayats and endow them with such powers and authority as may enable them to function as units of self-government. That is, Gandhiji thought that if the state has more power, then it will exploit the local people, and so that in according to him, the every village should be made self-sufficient, and that is why he thought of the Ram Raj and Gram Raj, Gram Swaraj, according to him, the every village should be independent. And it is on these thesis that the in 73rd amendment, the local government has been formed, and they are performing very well in the village areas, in the taluka, in blocks, and in the gram panchayats, and in the district panchayats. And similarly in the urban area, we find that the nagar nigam, nagar panchayats, and these are performing the same thing, and they are getting the funds from the government. So I think as we are giving the powers to these bodies, and these are now enshrined in the Indian Constitution 243. So, and this is Article 40. Article 41 talks about right to work and to aid who are in any way disabled to generate their own income. But here the government cannot give jobs to everybody, because it is the revenue sources which decides how much job can be given to the persons. So unemployment is going on, and we find that the population is increasing, and according to the population increase, there is no proportional increase in the jobs. But the motive of the government and the policy of the government should be that it should provide job to everybody, and if job is not being provided, then it should provide aid in the form of allowance, unemployment allowance, and it will also provide pensions, etc., to the old and the widows, etc., that government is doing. And that is of course the object of the welfare state. We talk about the Article 43. Article 43 talks about the wages in the industrial worker or in rural worker, and it says that the government should make laws for the basic or minimum wages, and these minimum wages must be living wages. That means the living wages, their wages should be raised to some extent, so that they can feed, and they can live in houses, and they can wear clothes, and besides this they should have some money for the education of their children and for the health care of their children. So then this will be called a living wage. And then we find that there is a 343A, where it has been provided that there will be a union of the laborers, and the labor union should participate with the management of the owner company. And if any kind of problem is generated, or if any kind of amount of profit is generated, then the profit should be shared with the employees also. And then there is another amendment 333, sorry, 43B, which talks about the cooperative. It has been done through the 97th Amendment Act. And thereafter we find Article 44. It is a much discussed topic, that it is here that the inheritance laws, the marriage laws, the uh, the laws relating to uh, adoption, inheritance, etc., for all the communities of India should be made one and the common law. And there has been a long debate in the Constitutional Assembly, but Constitutional Assembly, because of the dissenting people, did not agree, and that is why it has put this article into the state policy. And it has been expected by Dr. Bhimrao Ambedkar that the time will come when the people will adopt the same rule, that the same laws should be governed in the same field. Of course, we find when we try to read history that the Macaulay has said that there cannot be same rule in the field of the civil laws, because he felt that if these laws should be made one, then there will be a rebellion. And that is why he advised the government not to make a common law for inheritance and adoption and marriage, divorce, etc. And we come to the Article 45. The Article 45 has been amended by the 86th Amendment Act. Now it has been totally different thing which has been put in Article 45. Article 45 now says that the people who are the children, child care, health and child care should be provided to the people who are 0 to 6. And now the 6 to the boys and girls within the age group of 6 to 14 should get free and compulsory education, and this has now become a fundamental right under Article 21A of the Indian Constitution. And 86th Constitutional Amendment has also made another addition of the duties, fundamental duties, that the 11th duty is of the parent. Parent has to send every child within the age group of 6 to 14 to the schools. And now we come to the 45, Article 46. Article 46 talk about the educational and economic interest of the weaker section of the society, that is the SC and ST, should be saved at all cost, and government should act actively in it. Article 47 talks about the public health, and it says that the prohibition should be made that there should be no consumption of the beer, etc. And it also talks about that they should raise the level of the standard of living of the people, and the public health should be given and provided to all. And then we come to the 48, and here in the Article 48 it has been provided that the animal husbandry should be considered as an important developmental asset, and its breed should be changed, and developed breeds should be made available so that our population can get more and more profit. And we want to come to the Article 49. Article 49 is related with the heritage, that the different heritage of India that is Taj Mahal and Lal Killa and the other things, Ajanta, Ellora caves, etc., Khajuraho. These should be saved at all cost, and it is being saved by the national institution. And Article 50 talks about the separation of power between the executive, between the executive and the Supreme Court and the court. And now Article 51, which talks about international agreements. The international agreements are to be followed by the government, and for that purpose the government can order to follow the certain laws for any other state which are needed to implement and to enforce the international agreements. So now we come to the Article 4A, that is the fundamental duties. There are 11 fundamental duties of the people which are given, and we should also follow these duties. Now we enter into the Union Executive. The Article 52 says that there should be a President of India, and in Article 53 says that the President of India should have the executive power, and he will be the chief executive officer of the union, and he will have the chief commander. He will be the chief commander of the of the forces of India. And Article 54 talks about the what should be who should elect the electoral college. Electoral college for the president is all the members of the parliament, elected members of the parliament, and the elected members of the all legislatures, all state legislatures should form the electoral college for electing the President of India. And the next thing is in the next section it is provided that the Article 55 provides that the method of the electing the president, and here the here the proportional representation and single transferable vote method has been adopted. In Article 56 it has been said that the president the tenure of the president should be for 5 years. And Article 57 talks about the re-election of the president. President will be re-elected. And there are Article 58 which talks about the qualification. The qualification for the president is he should be the citizen of India, and he should have completed the age of 35, and he should have the qualification for being chosen as a member of the Lok Sabha. Now the Article 59 talks about some conditions. The one of the conditions is that his remuneration cannot be diminished during his tenure. Another is that he should not hold office of profit also. Office of profit, as you know, that where some kind of tests are there, where some kind of money, the person is being appointed by the government, and the person is under the control of the government, and person does the work of the public, and he can be dismissed by the government. Here the post will be decided as the office of profit. And now the Article 60 that is talks about the oath. President will take oath before joining the office. Article 61 talks about how president can be removed from his office. The only way to remove the president of office is the impeachment, and the impeachment can be done only on the ground of the disobedience of the Constitution of India, and one Lok Sabha bill, Lok Sabha or Rajya Sabha or one house at least inquire it, and it should the the proposal should be passed by two-thirds of the total membership of the one house, and it will again be passed by the other house by the total membership of that two-thirds of the total membership of that house. And now 62, if the president is tenure is complete, then the election should be completed before the president tenure, and if the certain kind of unavoidable things happen, then in that case the vote will be deferred, and at least in 6 months that the president must be elected. And we now come to the vice president. Vice president is under Article 62. There shall be a vice president, and vice president in Article 63 it has been said that the vice president will be the ex officio chairman of the Rajya Sabha. And we now come to the 65. Article 65 says when the president is not available due to certain uncertainties in the office of the president, then the office of the president should be run by the vice president as a president, and for certain time, and he will work as in charge of that, and he should have full power of the president. And thereafter there is a Article 66 in which the method of the election of the vice president is provided. The president is elected by the two houses of the Lok Sabha and Rajya Sabha, and the tenure of the office under Article 67 is the 5 years from the date on which he has taken the taken oath. And then we find Article 66, and there is a Article 66 which says that the election for that purpose must be completed before the completion of the tenure of 5 years. In section 69 we find that the vice president should take oath for that office. In Article 70 it has been said that if there are some kind of certainties which are not described above, in those conditions the vice president should act as a president. And in Article 70 we find that that if some kind of dispute arises relating to the election of the president, then it will be decided by the Supreme Court of India. Article 72 talks about the remission and of the conviction, etc., and especially in the imprisonment which has been awarded by the military court, that will directly go for the mercy appeal to the president. And if in second case, in all death sentences, the mercy appeal should be filed to the Supreme Court, to the president. And in other cases where the sentence has been given or conviction has been given, then the president should act on this, that the mercy appeal should be heard by him. We now come to the Article 74. Article 74 talks about there shall be Council of Ministers with the Prime Minister at the head to aid and advise the President, and the President shall act in accordance with such advice. Here we find that there is a president has only this power, that if he is not convinced uh, with the bill, then he can uh, send the ordinary bill for the reconsideration, and after the reconsideration when the bill is passed, the president has to accept it. In Article 75, it has been provided that the person can become a minister without being a member of the either house for 6 months, but in 6 months he should be uh, elected. And it has also been provided in 75.3 that the no confidence motion will be presented in the Lok Sabha, and this article also provides that all the ministers work till the pleasure of the president. So under these articles, these things have been written. Under Article 76, we find that there shall be Attorney General of India, and Attorney General of India will work till the pleasure of the president. Then we find that in Article 77, every bill should be taken in the name of the president. That when the bill is passed by both the houses, then it will be presented to the president. And in Article 75, it has been provided that the decision taken by the Council of Ministers should be apprised of to the President of India from time to time. In Article 79, we find that there shall be a Parliament, and Parliament shall constitute of the President and the Council of Ministers, President and the Rajya Sabha and Lok Sabha. In Article 80, it has been provided the Rajya Sabha, how the Rajya Sabha is constituted. 12 members will be nominated by the President who have excelled in the field of the arts, science, social service and literature, and maximum 238 members can be elected for the Rajya Sabha. That is, total must not be greater than 250. And then Article 81, it has been provided how the Lok Sabha is constituted. The Lok Sabha will have 550 members at most, and the 530 members will be elected from the states, and the 30 members at most will be elected from the union territories. And then there is Article 82, which Article 82 talks about the readjustment after the 10 years when the census is done, then the population is increased, then there should be a reorganization or delimitation commission should be made, and delimitation commission should change the boundaries of the area of the constituencies, either the parliamentary seat or the assembly seats. But it has not been done since 1976, and after the 84th Amendment Act, it has been frozen up to 2026. And then we find the 83 Article 80. In Article 83, it is provided that the duration of the Rajya Sabha or the Lok Sabha, as we know that in every second year, the 1/3 members from the Rajya Sabha will be retired, and that is a permanent house, and it is never dissolved. And then we find the second house, which is that is Lok Sabha. It will also have a 5-year term from the date which it has entered into office. But if the emergency under Article 352 is in force, then the duration of the Lok Sabha can be increased by 1 year, and at most it can be extended to 6 months from the date on which the cessation of the emergency has happened. In article, we find that in Article 85 there is a the president will uh, uh, declare when the prorogation of the house, etc. And in 86 the president will have power to call or make message to the either house or with the both the houses. And in every year when the first meeting, that is the budget session, is started, it is a special address is given by the president. In 87 it has been provided when the new Lok Sabha is chosen, and it conducts its first session, then the president will make to the both the houses a special address in both the houses with regard to the work of the government. In 88 we find that an attorney general will have power to be heard in all the parliamentary committees, but he will have no power to vote. In Article 89 it has been provided that there shall be a chairman or vice chairman of the Rajya Sabha. In Article 90 it has been said that when the deputy chairman or chairman are not or removed from the office or not in the office due to certain uncertainties, then the vice president, the deputy chairman will work as chairman. And in Article 91 it has been provided that when there is not a chairman, the deputy chairman will work as the chairman. In 1992 it has been provided that when a motion, certain proposal or motion is in the house for removing the chairman or the deputy chairman, and that person will not chair the house. But when the chairman's when the deputy chairman's removal is proposal is there, then when the votes are equal, then the chairman will have no power to vote. And in Article 93 we find that there will be a speaker and deputy speaker in the Lok Sabha. And in Article 94 we find that when they are removed, either of them are removed, then under 95 the deputy chairman will work as the chairman, deputy speaker will act as speaker. And in 97 it has been provided that the procedure how they can be if the proposal or motion is under consideration for the chairman or the speaker or deputy speaker. In that case we find that if the motion is to remove the deputy speaker, then the deputy speaker will not preside, and in that case, the speaker will cannot vote when the votes are equal. Uh, then there is Article 98 where it talks about the secretariat. In secretariat, uh, both the houses have certain kind of hierarchy of the officers. Uh, in the 99, it has been provided that the ministers or the members should have a oath of secrecy and uh, oath of uh, their designation. And thereafter we find that Article 100 talks about the how the what should be the quorum of the house, and quorum of the house will be 1/10 of the total membership of that house. Article 101, it talks about the Article 101 article we are talking about Article 102 is for the deciding the disqualification. The disqualification have been given under Article 102, and there are many things that if a person is undischarged, insolvent, if a person is unsound mind, or he is not citizen of India, these are the conditions. And in Article 103 we find that the disqualification can be disqualification matter is decided by the President. Yes. Now we come on 101. It has been when it has been told that how the post of the MP can be declared vacant. In 102, disqualification has been described, which I have already described you. That is, he should not be undischarged insolvent, he should not be unsound mind, he should not get the punishment after 2 years or more than 2 years. In 103, the president will decide the disqualification, and the president, when the matter is referred to the president should send it to the take some kind of advice from the Election Commission of India, and on the advice of the Election Commission of India, the president will remove certain person or not remove as the matter may be. In 104, if a person finds that he is disqualified and but the matter is not known to the authorities in the house, either in the lower house or in the upper house, and even then he participates in the proceedings of the house, then he will be uh, penalized by 500 rupees per day. In 105 we find that the ministers or that the ministers and the committee members and the MPs will all have uh, 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 special powers, that is they have some visheshadhikar, uh, privilege, some kind of privilege, and if something is done in the house, then the speaker or deputy speaker will hear the matter of the privilege regarding privilege. And in Article 106, it has been decided that the money and that the members what will be uh, the uh, allowances etc. to the members. I am member of both the houses. And now we come to the article. We come to Article 108, and 108 talks about 107. 107 says that when the bill is passed by one house, that is by the Rajya Sabha, and in between when it is sent to the Lok Sabha is dissolved, then the motion will not lapse. But if the motion is passed by the by the Lok Sabha and it is not passed by the Rajya Sabha and the Lok Sabha is dissolved, then the that bill also be dissolved. Under Article 108, there is a provision for the joint meeting when the two houses are totally disagreed on any point. There are three conditions. If the bill is passed from the first house and goes sent to the other house rejects its outrightly, or this the second house keeps the bill for 6 months or more than 6 months, and in other condition that they have finally disagreed with the view of the amendments, so that it cannot be finalized, then the president has a special power to call the combined session of both the houses, and in that house the bill is decided. And now the Article 109 says that if there is a money bill always be presented in the Lok Sabha, and it will always be represented after the after the sanction of the President of India. And if it is a general bill, then it can be presented in either house. As far as Section 109 says that for the money bill, the upper house has limited power. He can take with them for the 14 days to that bill, and if they do not give any opinion, if they do not send it after passing it, then the bill will be treated, then the money bill will be treated as passed in that state in which state it has been sent by the Lok Sabha. So they have hardly any power. In Article 109, it has been the money bill has been defined. It is money bill if a certain tax is imposed, or certain tax is reviewed, or certain tax is abolished or certain tax is revised or imposed, a new tax, these all will come into the money bill. And secondly, if certain kind of guarantee is given on the loan by the government, then it will also be treated as money bill. And thirdly, if a government decides that the some kind of expenditure is as will be treated as the vote on account, then it will also fall into that category. And in appropriation bill also be treated as money bill. So these are the conditions, and any money, if it is to be withdrawn from the consolidated fund of India or the contingency fund of India, then it will also be treated as money bill. In Article 111, when the bill is passed by both the houses of the Parliament, if it is money bill, then then the President is bound to give assent. And if it is not a money bill, it is ordinary bill, the President can keep with them for some time, and he can send again for the reconsideration to the Lok Sabha or Rajya Sabha. And if second time it is passed and sent to the President has no choice but to accept it, but to give his assent. In 112, it is called the budget article. In different departments gives their uh, uh, their estimation, and on this basis the tax is divided into two parts. One part is called vote on account, and other is that which is not votes on account. And then in 113, the estimation by the different departments are made, and the grants, demand for the grants to be made by to the government or to the President. And in 114, that is the appropriation bill is put into that house. And when that is put into the house, then it is treated to be uh, 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 new bill. And in this appropriation bill, how the money will be spent, it is decided. What are the rules and regulations are framed for the uh, for spending the money for certain purpose or certain department. In under 115, there is a provision for the uh, additional grants. If certain grants is given for the certain department, and department finds that there is a need of some more grants, then that bill is again presented in the house with the increased amount, and then it is passed. In 116, we find there is if 113 and 114 are not done, and there is a need to the government for the public purposes, then the government can take advance from it. So we find that in 117, we find that there is a finance bill. The finance bill is a bill which has some other qualities than the 110 or the money bill. If under 117, the finance bill contains all that what is given in the money bill, either one condition or the other condition. And besides this, it has also some other things also. Then it will treat a finance bill. And under Article 10117, it is provided that it will be presented in the Lok Sabha, and before presenting the Lok Sabha, it will have assent of the president also, but in this the second house gets more time to discuss it, and there is a provision for the joint sitting also. So some nature of the ordinary will crept into it, and in the 117.3 it has been provided the second kind of the finance bill, which talks about the some expenditure, but in this case it is the most likely that the will is like ordinary will, because in this there is a no need of the or though there is no need to taking consent of the president before presenting the will, but it should be given into his consideration. And secondly, it can be presented in both the houses, either in Lok Sabha or in Rajya Sabha, and the under 108 it has been provided that this will also be considered in that case. So money will has that the finance bill has more qualities than the money bill. All money bills are finance bills, all finance bills are not money bills. In Article 118, it has been provided that there will be the committees in 118 it is provided that the certain kind of rules are made by the uh, two houses of the parliament, and these are the bills through which the whole business of the government in Lok Sabha Rajya Sabha is done. In 119 we find that in all the bills what the law has been made, what the law has been made, they have to act only in accordance with that. Under Article 120, there is a provision that when one MP is to speak in the Parliament, he can speak in either Hindi or in English. If he cannot understand Hindi or English, then he will speak in his mother language. Suppose a person from Tamil Nadu is not able to understand Hindi or English, then he can speak in Tamil. And if an MP from Kerala is not able to understand Hindi and English, then he can express his ideas into his mother language, that is Malayalam. And in Article 121 we find that there is a provision for the Supreme Court and High Court, Supreme Court judges, that when they are giving judgment and when they are hearing some cases, and the conduct of that conduct during the hearing of the court cases cannot be discussed in the parliament. And in 122 it has been provided that the things which happen within the four walls of the Lok Sabha or Rajya Sabha cannot be discussed in the Supreme Court. Under Article 123 it has been provided that when both the houses are not in session and there is a need of some kind of law and some kind of rules and regulations are to be made, then the president has power to make law on all the subjects of the central list, and it will be treated as passed by both the houses and will have the same effect. But this will lapse when the two houses meet, and after the meeting of the two houses, after 6 weeks, if bill is not passed, then the bill will be lapsed. In Article 24, it has been provided the Supreme Court judge. The Supreme Court judge should be should have some qualifications. He should have held the office of the High Court judge for 5 years, and secondly, if a lawyer or if a lawyer have completed 10 years uh, uh, 10 years practice in the High Court, then he is also eligible for the becoming the Supreme Court judge. And if the President finds that there is a distinguished jurist, then he can also appoint that person as a High Court judge. In Article 125, we find that there is a provision for the judges, the allowances and the salaries, etc. That is the votes on account. And in Article 126, when there is a post of the CJI is vacant, Chief Justice of India is vacant, that the President can make any person of the any judge of the Supreme Court to act as a CJI. In Article 127, it has been provided that when the CJI thinks that there is a need of the ad hoc judges for a certain period of time to discharge the business, court's business, and that is there is a shortage of judges in certain constitutional bench, then the services of the ad hoc judges can also be taken from the High Court with the approval of the President. In Article 128, there is a provision for the judges who has retired. Their services can also be taken by the Supreme Court. In Article 129, it has been provided that the Supreme Court is a court of the record, that he has a power of punishing for his contempt, that if an order is not obeyed by any person, that it has unlimited power to punish any person for defamation, etc., or for contempt, etc. In Article 130, it has been provided that the President can there is a seat of the Supreme Court should be in New Delhi, and it can be changed with the presidential direction or presidential approval. The Supreme Court can make another place for hearing the judgment. In 138, it has been provided that the matters of original jurisdiction of the Supreme Court, if a dispute is between the center and the states, and center versus 2 or 3 states, or if there is a dispute between the one state versus other state, one state versus 2 other states, then all these matters will be treated as the primary jurisdiction of the Supreme Court, and they will be directly heard by the Supreme Court. And under Article 132, we find if a certain matter, which is High Court finds that the matter is related with the interpretation of certain law, then the matter will be referred to the Supreme Court. In under 132, we find that there is a provision for appeal from the High Court's order to the Supreme Court, and in 133 there is a procedure for appeal to the Supreme Court in the civil cases, and in 134 there is a provision for the criminal appeal to the Supreme Court from the High Court. In 135, if there is some case relating to the federal court, then the power of the federal court will be enjoyed by the Supreme Court judges. In Article 136, that is called the special leave to appeal, if government finds that the matter cannot be decided or cannot be uh, approached by the high court or the lower court, as a matter has arisen in the Manipur when there is a violence, the lower courts were not accepting these things, then the Supreme Court ordered that the special leave to appeal will be heard by them. Then there is Article 137. In 137 it is provided that the government can review its own judgment and it can reverse its judgment. In Golaknath case in 1967, the Supreme Court has said that there can be no law to amend the fundamental rights, or it cannot be amended under 368 because it is totally different law and it is sacred law. It cannot be touched by any other act. But the Supreme Court in Keswanand Bharati case has reversed the judgment and said that the law is it has said that the basic structure cannot be amended, otherwise the 368 has enough power to amend the fundamental rights, but it should be limited power and it cannot be exercised to contravene the basic structure of the Constitution. That is, the basic structure of the Constitution cannot be amended. In Article 139, it has been provided that the certain appeals under Article 32 of the Indian Constitution, 32 Class 2, are to be issued or heard under Article 139, and under Article 139A, it has been provided that when a certain case is pending before the Supreme Court and with High Court 1 and High Court 2, the matter relating to that matter is also pending, the Supreme Court will withdraw all the matter and the matter will be heard in the Supreme Court. Under Article 140, the Supreme Court has ancillary powers. That is, so that its decisions can be implemented. Under Article 141, it has been provided that the decision made by the Supreme Court will be followed by all the lower courts, either High Court, lower court, tribunal, etc. Under Article 142, the Supreme Court has inherent power to make the justice to be done. If certain order has been issued by the Supreme Court, but there is a need of further direction by the government, by the Supreme Court for implementing that earlier order, then the Supreme Court can issue that order under Article 142 under the inherent power. Under Article 143, the President of India has got the advisory power. He can, if the President of India thinks that there is a matter of fact or law, and that matter needs to be sent to the advice of the President, that the Chief Justice of India then can send for the advice to the Supreme Court. Under Article 143, this has been done. Under Article 144, it has been provided that the Supreme Court, if passes some order, then all the authorities below it, whether High Court, lower court, or a tribunal or any other body, should follow to implement that law. So they will act in the direction of implementing it, and they will not make it to make the order make the order not to be implemented. They should instead they should take steps to implement it. Under Article 145, it has been found that there is a provision that all the officers and the employees who work in the Supreme Court will be done by the appointment will be done by the Supreme Court, and the salaries will be come under the votes on account. And last in Article 146, in Article 146, government that the Supreme Court can in Article 147, there is a provision for the government that if the Supreme Court finds that the interpretation of certain law it cannot be done belonging to the Constitution of India, then it for interpretation of the law, the help of the Government of India Act 1935 and the Indian Independence Act will be taken into account. So that's all today. I think you will have understood the common, the brief interpretation of the Act of Articles of the Indian Constitution. Thank you very much.